The role of preliminary hearings in Oklahoma criminal justice system. I'm Tulsa Attorney James Worth, and that is the issue that we're dealing with. What is the preliminary hearing? What is it for? Well, in the state of Oklahoma, by the Constitution, you are entitled to a preliminary hearing if there's not like a grand jury indictment. And that preliminary hearing is there to serve multiple purposes. Essentially, it's a prerequisite for the state to show and demonstrate before an impartial judge that there is sufficient evidence before you go on jeopardy at a trial, and that is to show probable cause is the standard, that there is that a crime was committed and that the defendant committed the crime. So it's to act as a probable cause assessment to ensure that before one has to go forward and put on a trial, the state has already demonstrated probable cause a crime was committed and that the defendant committed it. And it's also a screening function to ensure that only relatively strong cases move forward, and that if there is sufficient evidence to accuse somebody, that it's kicked at that point before they're at jeopardy of imprisonment by going to an actual trial. Also, it's an opportunity for the disclosure of evidence. From the defendant's perspective, it's an opportunity to find out what evidence the state has, to cross-examine those witnesses, and to use it essentially as a discovery hearing to a degree in order to help prepare for an ultimate trial. It's also, the purpose is to protect the defendant's rights, to safeguard constitutional rights, including the right to confront witnesses, and also to potentially challenge Fourth Amendment violations or Fifth Amendment violations if they're trying to use that as evidence in the case. And then, practically speaking, the preliminary hearing is an opportunity to negotiate. Most cases ultimately get resolved through a plea deal rather than actually going to a formal jury trial or bench trial. And the preliminary hearing is a great opportunity to do that because you've got all the parties present at the same time, which means they can sit down while they've reviewed the case and prepared to put on a hearing. They know what the facts are, they know what the circumstances are, they know the strengths of the witnesses, so it's a good opportunity to negotiate to see if a plea deal can be reached. That's where you can meet with a prosecutor ahead of putting on that hearing, talk about weaknesses potentially in the case, strengths regarding the defendant, and potentially work something out to avoid the risk of a trial so that everybody knows what they're getting and can reach a mutually acceptable deal there. So that's the purpose of a preliminary hearing in the state of Oklahoma if you're dealing with a criminal case. And I should note, preliminary hearings are for felony cases. They are not for misdemeanors. Misdemeanors under Oklahoma law, you're not required to provide a preliminary hearing. That can go to trial without a prior probable cause determination. But if you're dealing with felony charges in the state of Oklahoma, then you are entitled to that preliminary hearing. So you're going to want to talk to an attorney privately and confidentially about how to handle that best and to get set up for your defense. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.